R.D. Rye. I teach patent law here at Duke, and I want to welcome all of you to our Information Ecology lecture. As usual, Jennifer Jenkins has done a great job of publicity, so we have a really nice crowd, and here comes Bob Quick-Teagan, for whom we've been waiting. I'm joking, Bob. I just mentioned you to our distinguished guest. Our guest is Jim Bessen, whom it's fair to say I'm absolutely delighted to have. I've already had my patent law students, some of whom are in this room, read one of his very influential, a short version, I should say, of one of his very influential articles, an empirical study of software patenting. In general, Jim, I think, has had more influence on policy debates than most academics working in this area, and has simultaneously been a very thorough and scholarly student of patent policy and law. Currently, Jim is a lecturer at Boston University, and he's also the director of Research on Innovation, which is a think tank devoted to studying innovation questions, and puts out a quarterly newsletter summarizing all of the latest research in the area of innovation, which is cross-disciplinary and therefore extremely useful to many of us who need to know about a lot of literature in the social sciences and yet wouldn't necessarily be exposed to it otherwise. So I'd encourage you to inquire more about that newsletter if you're so interested. In addition to doing his interesting work on software patenting, Jim has been doing a lot of great work recently on patent litigation and trends in patent litigation, some of which I hope he will speak about today. Jim's background is a very interesting one. He's been a software designer, innovator. He wrote one of the first successful desktop publishing programs in the early 80s and was CEO of a successful software company, so he really knows whereof he speaks when he talks about software patents. And actually his work was very influential in the European Union in terms of their influencing their policy on what to do, whether to allow software patents, cross-software patents. In addition to working at Boston University, he's also done research at MIT on questions related to some of the stuff that one of our prior speakers, Eric Van Hippel, spoke about, open source innovation. So without further ado, welcome. And thanks. The talk will be the empirical evidence on patents. Do they work as property?
Well, the patent system's been in the news a lot lately. You see a lot of news reports of people complaining about bad quality patents. There have been reform proposals advanced. Some of these are working their way through Congress. You'll find some people will tell you that the patent system is completely broken, especially in areas such as software. Other people will tell you just as confidently that all it needs is a few specific reforms, a few tweaks, and it will be just fine. And yet other people will tell you that the patent system as it stands today is just fine, and that any attempts to reform it are really attempts to subvert the rights of the independent inventor. Interestingly, almost all those arguments are made without a whole lot of evidence. There is evidence about some of the specific proposals, such as post-grant opposition, but no one's really done very much, as far as we can tell, in terms of way of an overall assessment of the economic performance of the patent system. So a few years ago, Mike Moyer and I decided to see what could we pull together that might reflect on the performance of the patent system as a whole. We realized pretty quickly that's an ambitious goal. We're not likely to come up with a number of the net social welfare of the patent system is X. But instead, we thought we might be able to answer a more limited question, which is nevertheless central: do patents work as property? Not are patents property. That is, we don't want to ask, we're not concerned about the philosophical inquiry of are patents a natural right and that sort of thing. We're convinced that whatever you call patents, patent law and the law for tangible property are sufficiently similar that we should expect them to operate in similar ways. Nor do we want to ask, should patents be property? A lot of people have raised ideas that maybe there are better ways to provide incentives for innovation, rewards, or R&D subsidies, or a liability regime. We don't want to get into those things. Instead, we want to just ask a more limited question: do patents actually operate as property? And the main reason we want to ask this question is we think we can answer it based on empirical evidence. But there are two other reasons, and they're both important. I mean, we think this is a central question. One, there's a very persuasive argument that goes something like this. Property rights have been very important as an engine of economic growth. They provide incentives for investment. Patents are property rights, therefore patents should also provide incentives for investment in technology. It's a strong argument, but it hinges critically on whether, in fact, patents do operate as property. The third reason we think this is an important question to ask is the concern about the performance of patents as property is really antecedent to many of the other issues that people are concerned about. So, for instance, some people are concerned and raise a concern about the fragmentation of rights, that there are too many rights that make transactions difficult. Having a proliferation of rights is one problem, but having a proliferation of rights that are poorly defined is a much, much worse problem. So it's critical, we think, to get the property rights figured out in the first place. If we have a problem with the definition of rights, then some of those other problems are going to be much more severe. All right, so we started our inquiry by reviewing the literature. It's been 50 years since Fritz Machlup was really the last person to try any sort of comprehensive review of the empirical literature, and there's been a lot of literature written. We looked at historical studies, we looked at cross-country regressions, natural economic experiments. If we wanted to boil down what we derived from reading all this, it's that implementation matters with all sorts of property rights. It's not enough to simply have a property statute on the books. What matters are the regulations, the institutions, the social norms that support that. Particularly so for patents. The patent system seems to be particularly sensitive, historically, to the details of how it's implemented. If you want to summarize the overall performance of the patent system through history, it's been very spotty. It's been very mixed. You can find examples where it's worked well, and you can find lots of examples where it hasn't worked. For instance, one of the things that scholars have focused on is the Industrial Revolution. Douglas North, the Nobel laureate in economics, has argued very persuasively that general property rights were critical in the British Industrial Revolution. Britain was the first country to experience the Industrial Revolution. Property rights provided incentives for investments. Property rights helped markets grow and flourish. Property rights enabled new forms of finance that shared risk, so that an innovator, say, could invest in a new technology without having to fear going to debtor's prison if the technology didn't work anymore. While economic historians I think there's a strong consensus that property benefited the Industrial Revolution, there's much more skepticism about the role of patents specifically. Joel Mokyr points out the reason for this is that, in fact, if you look at the inventors of the Industrial Revolution, very few of them actually benefited from patents. So we have James Hargreaves and Samuel Crompton invented early textile spinning machines. Neither one of them obtained patents. The reason Crompton didn't obtain a patent is because Arkwright had a very, very broad patent on textile technology, spinning technology. But Arkwright's patent was challenged in court, and it was invalidated. Nevertheless, Arkwright went on to make a fortune without a patent. Edmund Cartwright invented the power loom. Richard Roberts invented automated spinning machines. They both obtained patents, but neither one of them recouped their investments, even though these devices turned out to be very influential in the Industrial Revolution. James Watt's probably the happy exception. Watt invented some improvements to the steam engine, and he patented them, and the firm of Boulton and Watt held a monopoly for over 20 years that was quite profitable on sophisticated steam engines. John Kay invented a weaving shuttle. The Fourdrinier brothers invented paper-making processes. Both of them obtained patents. both of them were nearly ruined by the costs of litigation. So it's hard to say with this sort of record that with much confidence that patents really contributed much to the British Industrial Revolution. It's a different story in the US. Zarina Khan and Ken Sokoloff have argued and shown some good evidence that inventors did benefit from patents in the US. Very different patent system, a much later Industrial Revolution. The US, of course, copied much of its technology from Britain. They were pirates in those days. But a different implementation. Petra Moser has compared countries across, done cross-country comparisons for the 19th century, and she finds that nations with patent systems were no more innovative than nations without patent systems. It didn't make a crucial difference in their level of innovation, although it may have affected their technology choices. So it's a very mixed record, and it seems to depend on the details. So maybe we want to ask, how can patents work? How does property work? How does it provide these benefits, and how can patents do them? The usual argument is patents provide, or property rights generally provide incentives. Incentives to make investment, secure that I'll be able to reap returns, incentives to sell things, secure that I'll be able to receive just compensation. So for instance, a farmer can invest in crop development, secure that he'll be able to, he won't have his crops stolen by a neighbor or expropriated by a government. A farmer can sell his crops and be secure that he'll receive proper exchange. Of course, property rights aren't the only ways to secure investment and trade. There are such things as private enforcement. A farmer can hire his own police force, can set up fences, set up security systems. There are other ways that people have studied, such as social norms. Not all social norms are done by hippies. I live in a town with several hundred lobstermen. They don't look like that, at least not with their gear on. But they have a well-developed system of social norms where they regulate the catch. It's been well studied to prevent overfishing. So what then is the advantage of property? The advantage of property rights, what's the advantage of property compared to, if you can do private enforcement and set up social norms, why have property? Property can be much more efficient. That's the critical thing. Property, it's much more efficient to have a county police force than it is for each farmer to hire his own police force. There are economies of scale. Also, because once you have a powerful government-backed police force, people will tend to respect the law. Social norms can reinforce property, and it becomes a very efficient self-policing system. So the reality is very few farmers have to have their borders patrolled by the local police force because neighbors respect their rights. So why is it that sometimes things go wrong with property? Well, economic historian Dutton, who's overall rather pro-patent, points out that the problem you had in the British Industrial Revolution was that prior to 1830, the law was uncertain, there was a lot of litigation, and we can see that a lot of these people were involved in litigation either directly, Kay and Fournier losing their shirts at it, Arkwright losing his patent, or indirectly, Crompton not getting a patent, essentially for fear of litigation. So property rights can provide incentives, but when there are costs and disputes, these can counteract the incentives. Litigation, disputes, uncertainty are all costs imposed on innovators. And if the costs of innovation exceed the benefits, then it's no longer providing strong and efficient enforcement. We can look at examples in real property where the enforcement was inefficient and the property systems broke down. So when the U.S. took over California in the 1850s and 1860s, the status of land titles that had been granted by Mexico were unclear. This led to squatting, this led to a lot of litigation, this led to violence, and this led to a decline in agricultural productivity. When mineral rights were unclear in Montana, it led to shooting wars. You can look at the experience of the former Soviet economies, and they vary tremendously. Some economists make a pretty persuasive argument that a lot of it has to do depending on how they've implemented property systems. Some, such as Poland, are experiencing rapid growth. Others are basically at a lower GDP per capita than they were under the Soviet system. So the key concept, at least as far as Mike and I are concerned, is property can have fuzzy boundaries. If I'm going to build a building, I want to know that I'm not going to end up in a lawsuit because somebody else thinks I've built on their land. I want to be able to provide clearance. You very rarely find in real properties lawsuits where somebody's built an expensive building on somebody else's land. You very frequently, or not infrequently, find that with patents. Inadvertent infringement. People invest millions of dollars into technology, and then someone else comes along and says, no, you're infringing on my land, my patent. So the incentives can be counteracted by fuzzy boundaries. So let me get to the meat of the matter, which is our empirical study of current day patent system. This discussion provides a framework for how we can think about whether patents work as property today. So we want to compare the incentives with the costs that are imposed on innovators by disputes. If the system is providing net incentives that are positive, then we know it's working well. If the costs of disputes exceed the incentives provided, we know for sure that the patent system is not working well as a property system. So we wanted to basically estimate these two things, the incentives and the dispute costs, and we'll weight our comparison in favor of the patent system by estimating a lower bound on dispute costs. The value of incentives, we're talking about the private incentive, so it's the private value of a patent to its owner. As a patent owner, I can make extra profits by excluding people from the market, or I can make profits by licensing my technology or selling my patent. All of those provide me private value, and if I can estimate that private value, that's the magnitude of the reward the patent system provides. Well, in fact, economists have developed two techniques, and we use both of them to get independent estimates of the private value of patents. One is based on renewal data. Patents experience renewal fees. To keep a patent in force, you have to pay the fee. Basically, this is a sophisticated system where if we observe that, say, somebody declines a $2,000 fee, we know that their patent is no longer worth $2,000. The other method is based on the observed behavior of investors. If a public firm, has patents that are valuable, those patents add to the value of the firm, so we can look at the stock market value of the firm and relate it to the capital assets of the firm and the R&D assets of the firm, and using a regression analysis, tweak out the contribution that patents make to the firm. So we've done both of these, and we find, fortunately, that our estimates agree, which tells us that, more or less, tells us that we can have some degree of confidence in them. For instance, these are the numbers based on renewal values for 1991. The mean patent was worth $78,000. The median patent was worth a lot less. That's because most of the value of patents comes from the top 5 or 10% of the most valuable patents. If we add that all together, we find that the aggregate value for U.S. patents granted to U.S. Individuals and corporations in 1991 was about $4 billion. Now, that's a pretty sizable number. It's not as large, perhaps, as some people might like to think it is. By comparison, in 1991, the federal government spent about $26 billion on direct subsidies to industrial R&D. So it's clear that patents aren't the only or even the most significant form of economic incentive provided to innovators. But nevertheless, if we have a well-functioning system, a $4 billion incentive per year is very significant. One important metric is to relate that to the cost of the associated R&D which produced that value. We find that number to be 2%. This can be loosely interpreted as a kind of subsidy, so that if I spend $1 on R&D, I'm going to have $1.02 of total value. Okay, that's the incentive part. On the other side of the balance, we have dispute costs. Not all disputes appear in the public record, so we're going to constrain ourselves to just look at those that do end up in lawsuits being filed. This is a lower bound estimate on dispute costs, as I mentioned. Basically, we want to look at the expected cost that an innovator will have to spend to defend against being sued for infringement. So this is the probability of being sued times the expected loss once I am conditional on being sued. So we estimate each of these things separately. Now, the first thing to look at is the number of patent lawsuits has exploded, nearly tripled since the late 80s. We do a regression analysis to understand what factors drive this. R&D is important. Patent portfolio size is important. We find legal changes probably, or the unexplained portion at least, being the most significant factor driving the increase. The other component is the size of the loss. And we're talking about the total losses that a firm might experience if it's sued. So legal costs is one aspect of it, and we do estimate those, but they end up to be a relatively small part of the total loss. We can also estimate the loss of firm value, which is a proxy for what investors think the expected long-term loss of wealth will be. So we do this by looking at what happens to the stock markets of the various parties, the stock market value when a lawsuit is announced or when a lawsuit is filed. This shows the daily reaction. The defendant's stock market drops, the plaintiff's doesn't go up, maybe it drops a little bit. So we do a regression analysis with some 700 firms where we have detailed information on both the plaintiffs and defendants. We find that the mean loss of wealth is about 1.3%. That this number is much larger for R&D intensive firms. All right, so we pull all these numbers together. We can get our litigation risk for 1987, we estimate, this is the probability times the expected size of the loss, at 0.7% of R&D. We compare that to a 2% incentive for R&D, and we say in 1987 things were working pretty well. There was a net incentive, a net positive incentive provided by the patent system. But by 1999, the situation's flipped. We estimate, using very conservative estimates here, of 4% of R&D goes to defense, expected cost of defense against infringement, compared to a 2% benefit from patents. So basically, in 1987, the patent system provided a net subsidy. In 1999, it provided a net tax on innovators. Okay, well, why? What's going on? I mean, we have a number that doesn't look good. Let's try to understand what this is and what we might be able to do about it. Fuzzy boundaries, right? What is it about the patent system that might make boundaries fuzzy compared to a system of tangible property rights? We start by looking at some of the institutions of the system in place for tangible property and how they help investors, economic agents, understand the boundaries of property. So one, there are mechanisms for efficient clearance of rights and efficient enforcement. Think about land. There is third-party verification. I can hire a surveyor to determine the plots of my land so that I don't build on somebody else's land. In addition, that surveyor's findings can have a significant role in any judicial proceedings. Judges defer to surveyors. They don't reinterpret the findings of surveyors. And there's a registry. There's a public registry so that all of the deeds are recorded. I can go to the registry and find out the coordinate plots for my neighbor's land just to make sure that there's no potential conflict. All of those things make property and land transparent. Even with those institutions, there's still instances in tangible property where boundaries are still fuzzy. This is particularly true when property is extracted directly from nature. For example, mineral rights or rights in game and fish. So for instance, if I catch a fish, I might want to claim the whole school of fish, but I don't really have actual possession. I can't I can't cook any more fish than I've actually caught. But I might conceivably get property rights to those. And then if someone else comes along later and actually catches the fish and can do something productive for society with that fish, we're going to have a conflict. We're going to have a dispute. Well, for that reason, property rights systems generally have a requirement that there be actual possession. I can get a property right to the fish, but I can't claim a right to the whole school. There are similar restrictions with mineral rights, which is where this is perhaps more interesting than fish and game. But basically, the intent of these sorts of restrictions is that it limits this sort of opportunistic dispute where somebody can own a property right, yet not really in a position to develop it, to make the investments to make it socially valuable. This puts things more in conjunction and leaves the boundaries very clear. The other sorts of things that various property systems do is a variety of other regulations that limit the rights where there might be this kind of opportunistic dispute. So for instance, with mineral rights, there are typically requirements that the claim be worked. There are requirements that annual fees be paid. There are requirements that of other sorts, for instance, oil wells in many jurisdictions can't be placed too closely to one another so that there's a limit on the number of rights that are out there. All of these things limiting some of these opportunistic disputes. Finally, tangible property has well-developed insurance markets. When I buy a house or land, I can get title insurance for a very small fraction of the purchase price, and this will protect me against any mistakes the surveyor may have made or any disputes about the origins of the title. Well, what are the comparable things the patent system has to offer? Basically, you don't have third-party verification. If I'm developing a new technology, all I can do is ask my lawyer what he thinks about whether I'm infringing somebody's patent. The PTO does play a fact-finding role, but that role is largely complete once the patent is issued. Artie has written about how within the judicial process there isn't any particularly great degree of deference to the fact finders, that in particular with claim construction, the way a patent claim gets interpreted gets reviewed and very frequently gets overturned on appeal. The appellate reversal rate is something like 30 to 50%, depending on which study you read, on cases where claim construction is appealed. There is a registry. It's a very important part of the patent system, is the database that can be searched of existing patents. But there's one aspect of that registry which differs very significantly from tangible property, which is that claims can be hidden. And there are two ways this happens. One, a patent is enforced from the date of application. It may be the case that I don't know that that patent is enforced while I'm making investments, and only when the patent is issued and finally published can I discover that my technology may infringe on its claim. So there's a period of time when the patent claims are hidden from me. There's a procedure known as continuations where basically a patent applicant can extend that time even further. So there can be, it seems to be a significant role in litigation actually, significant opportunities for a patent applicant to maintain claims that no one in the world knows about other than the applicant and the patent examiner. Regarding actual possession, the patent system does have a very elaborate system of priority, the first to invent rules, but there have been a couple developments, especially in the last decade or so, that have tended to undermine aspects of actual possession. One is abstract claims in patents. Patents have been allowed increasingly, in our view, to claim some very abstract things where it's very hard to know what the boundaries are. Two, we think there are increasing situations where patents are granted that cover technologies that aren't yet developed, that the inventor gets more than what a right that's broader than what they actually invent. Let me talk about an example of this. This is the famous Freeney patent, or e-data patent, a system for reproducing information in material objects at a point of sale location. Basically, Freeney invented a system that would sit in a store or as a vending machine. You'd go in, give your credit card info, say select a song track from a listing. It would download the data for that song track and print out a tape at this point of time, an 8-track tape or so. It was originally run on Apple II computers. Now, the critical thing about this patent or one critical thing is, what's the meaning of a point of sale location? The company eData got a hold of this and began asserting this patent against anybody doing digital e-commerce. Well, I can do digital e-commerce in my bedroom. I can download a song in my bedroom. Is that a point of sale location? What does the point of sale location mean? Well, the district court said if it's in your bedroom, it's not a point of sale location. The appeals court said, no, your bedroom is a point of sale location. So the point is, there was this long period of time where anybody developing any technology for digital e-commerce, which was thousands and thousands of innovators, could not have known what point of sale location meant and could not have known what the boundaries of this patent were. That led to disputes and did lead to lawsuits. The patent, other aspect, some of the other regulations that tangible property systems have to reduce opportunistic litigation, the patent system does have renewal fees, but these are very minimal. And finally, patent insurance defense is a non-existent market in the US and has been for quite some time. You cannot get defense against being sued for infringement, insurance against being sued for infringement. Okay. One thing to note is a lot of these changes are changes that have come through in the last 10 or 15 years. The law regarding claim construction was changed during the mid-90s, and this has led to these high rates of appellate reversal. Continuation practice was around since the 19th century, but during the 1990s, it's been used much more intensively, despite some changes in the statute which limit the worst abuses. The issues about abstract claims and yet to be discovered technologies largely appear to relate to attempts to extend the patent system to cover software and biotech innovations. So these are all recent developments which may explain why things have changed between 1987 and 1999. All right, so what can we draw from this? The patents work as property? Well, yeah, if the boundaries aren't fuzzy, but maybe that's not the case we have today. So the bad news is it's broken. Good news, well, the tax that we're experiencing isn't large. It's not strangling innovation today. It may be inhibiting or breaking innovation, but it's not, sometimes people will argue that, well, we couldn't have a problem with the patent system because we're so innovative. Well, we could be more innovative, but I think we're in that intermediate range. The other good news is, well, the system worked in 1987. Maybe the genie can be put back in the bottle, but it might require strong medicine. We can look at some of the institutional issues and maybe get some ideas about what sort of reforms might be useful. It would be possible to set up a system of third-party verification. The Patent Office could offer non-infringement opinions. I'm developing a new technology. I want to know whether I'm infringing somebody's patent. I could go to the Patent Office, pay them a fee, have them issue me an opinion that says you're infringing or you're not infringing. And maybe that opinion could even have some presumptive value if a lawsuit were later to develop. The UK Patent Office has just started an experimental service of this sort. Deference to fact finders, actually Artie has written about this in great depth. There clearly are some changes in the structure of the courts or possibly the law that may address that, and I won't steal Artie's thunder. A number of scholars have called for abolition of continuations or other ways to restrict continuation practice. That would seem to be a good idea from our point of view. Abstract claims, yet to be discovered technologies. A lot of this had to do with changes in the law that were made to accommodate new technologies. I believe some of these can be reversed. This may go against the trend and the desires of some of the judges making those decisions, but this isn't an impossible thing to think about. A number of economists have suggested that patent renewals fees should be much steeper. And if they were, this would tend to weed out a lot of the opportunistic patents. That seems to be a good idea. This set of reforms and this set of concerns is, as I said at the beginning, only one narrow but we think central set of issues. There are other issues, but we tend to think a lot of those other issues may be exacerbated by the problems of fuzzy boundaries. For instance, there's a lot of concern that there are many obvious patents being granted. The Freeney patent might seem to be a very obvious patent. But it's much worse to have a whole lot of obvious patents that are also have fuzzy boundaries. That seemed to be the case with the Freeney patent. There are other reforms that are certainly valuable. One we think is probably a good reform is post-grant opposition. This is a reform where third parties would be able to come up and present prior art that might invalidate a patent after the patent's been issued. But again, we think without clear patent boundaries, a reform like this might not work very well. The whole process of comparing a patent to the prior art depends on how you define what the boundaries of the patent are. If you don't have very clear boundaries, you're not going to necessarily find the prior art. With a Freeney patent, for instance, there is prior art that would have invalidated it if it had been interpreted as being an e-commerce patent, digital e-commerce patent. So these things are not unrelated. So to conclude, I would say if we're going to have a patent system, we should at least have one that works well and works as property. Thanks.
We have lots of hands already. Probably about 20 minutes for questions. Let's see. The woman in the...
So you said that these fuzzy boundaries are the problem. I wondered if you found those more in the areas of the unpredictable arts and the newly developing art units as opposed to the more established ones like the mechanical art.
Well, what you find is that litigation rates are higher in the new technology areas. Yes, like litigation per patent is higher and software is higher in biotech, yes.
When you measured the incentives of the patents, did you discount for the cost of actually running the patent system and getting the patents? So, for instance, all legal fees and filing fees? Yeah,
this is the cost at the date of issue. So you've already spent what you need to get the patent. It should reflect theoretically the cost that you might incur enforcing the patent.
But it doesn't. But it does. You've subtracted all the filing fees and so forth.
No. We're calculating it as of the date after those have been spent. So we're not counting those. We assume that the parties wouldn't have spent that money unless it had been worthwhile for them to do so.
Okay.
Jake.
I love the presentation, and it strongly accords with my intuitions, which makes me very suspicious of it. So the real question is, you said you were doing something very modest, but there is the assumption that it's the property or non-property quality that really drives your graph in terms of change in the proportion of incentives to costs. And so I wanted to throw out some alternative explanations and ask whether you considered them and how you tried to deal with them. So there is a school of thought that says it'd be great to have really fuzzy patents. Ian Ayers, for example, argues that we should have patents of uncertain length. You wouldn't know until litigation what length the patent was. Maybe it's a 15-year patent, maybe it's a 20-year patent. You open the box, you'll find out. On the theory that it's the last marginal units of extraction of the monopoly that cause the greatest social harm. So we should have really, patents are unclear in scope and duration. So maybe what happened is that patents got clearer because the Federal Circuit is so fabulous at its job. No, it's not my conclusion, I have to say. But, and two other possibilities. One of the things that happens during the time that you're looking at here is an enormous change in terms of the culture of patenting, how often patents are sought, belief that this is more important, So one possibility is the system works okay so long as no one's actually enforcing the rights. And that actually, we have lots of examples in the legal system of, so long as nobody actually tries to make this machine work, it'll be beautiful. But if you actually try to operate it the way it's supposed to, it will collapse. And that could be enough. And then the final one, technology cycles. You see enormous inventiveness at beginnings of technology cycles, massive innovation, generally leading to small firms become bloated, and then what do? Well, we're not inventing anything anymore, let's sue people. So to what extent, so maybe we're at the end of a technology cycle. So maybe the problem is that we're getting too clear, maybe the problem is the whole culture is screwed up, maybe the problem is just that we are at the end of a technological cycle. Those are all possible explanations. How did you try and get at whether or not that was the one that was going on here?
Okay, I'm going to skip the Ian Ayres one. I'll focus on the other two. Well, so for tech cycles, one of the things we looked at, you would expect, if it's a tech cycle explanation, that there would be certain industries where this was happening and certain industries where it wasn't. Tended to be true across the board with very little variation. In terms of use, well,
That doesn't come against the mechanical arts point?
there's a higher rate. There is a higher rate in per patent. There's a higher rate per patent in of litigation in software and biotech. But once you aggregate things up on at an industry's level, the differences are just not significant. You see, I'm pulling this from my head, but you'll see growth rates in the litigation hazard of 5 to 7% a year. So you may have software being 7% and mechanical or more traditional industry being at 5%, but you're not talking about huge differences. Instruments may be there was one industry which was close to being an outlier, wasn't statistically significant, but I think the basic story still holds that way. There is actually there is empirical evidence, by the way, that patenting does tend to come late in the industry cycle. So that Gort and Klepper have shown this, and I think it's an important explanation, and it may be part of what's going on, but what that tells us is it's not most of what's going on. In terms of use, we're essentially counting use by looking at patent portfolio sizes. So we can look at litigation both and we can include the size of the plaintiff's portfolio, the size of the defendant's portfolio. That's telling us how much they're patenting. That does have something, that does play into it, but it doesn't explain the change. We have this down at one analysis. We're looking at the probability that firm A sues firm B, depending on the characteristics of firms A and B. So it has nothing to do with.
I couldn't quite make out your graph, the vertical axis, and I'm trying to figure out what caused the flip. And the story I think you're telling us is part of the reason, the underlying reason, is the fuzziness increase. And that's what's driving the likelihood of, but was that a count of number of cases? Was it a count of number of cases relative to number of patents? Was it a cost per case of litigation?
It was relative to R&D. So we were, I think I know which, you're talking about the 1987, 1999 comparison. Yeah. So it's the value of the rewards or the incentives relative to R&D and the value of the expected litigation-related losses relative to R&D. So what your question translates to then, what is it that drove the increase? And it's a couple things, but it's both an increased probability of being sued, which in terms of R&D went up 70%. So a firm is for per R&D dollar it spends, it's 70% more likely to be sued in 1999 per R&D dollar than it was in 1987 per R&D dollar. And particularly for R&D intensive firms, essentially R&D intensity increased. Firms are spending more on R&D, So both the frequency and the size of the losses are going up.
Just following up on that, is the relationship of subsidy to tax, or the change from subsidy to tax, that's also robust across industries? Because, conventional wisdom, of course, is that that patents are much more of an incentive in certain industries than others.
Yeah, we're trying to, I have to say, we're still playing with that. The analysis becomes a lot harder when you break it down to smaller groups. So I'll beg off on that question.
Given this highly skewed patent distribution, don't you have to get into what the value of the patents that are in litigation? And wouldn't that be a kind of key issue? And then just as a footnote, in pharma, which I do a lot of work on, it is there's a bounty to generics to sue the most important drug patents. You get 180-day exclusivity. So if you look over your period in pharma, there's an enormous increase in litigation associated with this bounty. And it really is focused on the Prozacs and Viagras, et cetera, because that's where the money is. It's like Willie Sutton said, that's why I rob banks.
Yeah. We tried controlling for generics in pharma. I'm not sure we did it adequately yet, but that's one of the tweaks we're playing around with, because Hatch-Waxman has a very specific influence on litigation there. It is the more valuable patents that do get litigated, and we have a number. We can put numbers on that. That doesn't affect the nature of the analysis, though. Those are the ones that get litigated, but
You're saying they've always been the ones that got litigated.
right.
Yes.
Let me go back to the question about the cost of IP, of obtaining IP, and was wondering about the fuzziness of the boundary in terms of the implication test for companies kind of carving out territory on broad patents, in terms of like how boundary fuzziness encourages firms to increase patent volume. It was up at the USPTO at the conference. They had an open source software, and the Microsoft people were discussing. So there's some discussion at Microsoft in terms of the 3,000 patents they're generating through, not because they want to necessarily, but because of the fact they feel like because the boundaries are fuzzy, they're required to increase the breadth. And I wonder if that feeds back into the cost equation in a way that's significant to the research budgets that you're talking about.
Yeah, so there's this more general argument that firms need to acquire these patents to protect themselves, to do defensive patenting. We find some evidence that defensive patenting takes place and has some effect, but it tends to only be something that occurs between firms that are close rivals in the same industry and technologically close. When you add it up into the total picture, it seems that even though firms tell you they're getting these for defensive reasons only, they end up suing, depending on, all of a sudden Adobe, I'll give you for instance, Adobe software, which spoke against software patents in the early 90s and, said it was being dragged to get patents, then ends up starting to sue other firms because it's got the ammunition to do so.
Let's see. Just following the red shirt.
In a free market economy, you might expect people to be able to decide whether or not to take advantage of this patent property by licensing it from somebody else, or alternatively, if it was cheaper to try to design around it. Yet you mentioned the problem of patents being hidden to a certain extent, that they're not public until they go into effect oftentimes, with no advance warning for somebody that may have committed to doing research years before them. Are there any proposals to try to rectify that problem, perhaps have a period where they're published before they actually go into effect and somebody could claim legal liability? Yeah,
there's been action on this for some 10 years now, I guess. Which seems, in my opinion at least, to be fairly ineffectual.
Although they do have about 90% of patents are published after 18 months, U.S. patents.
Yeah, but of course then the claims may still change even after they're published. So there is some publication, so you're getting some warning about what's out there, but in terms of exactly what the claims are, and how those claims are going to be interpreted, you're in a pretty, any innovator's in a difficult situation.
Do you think it would help if there was some period where after the claims were finalized and the patent actually was issued before it actually went into effect to give businesses that opportunity to decide if it was more cost effective to design around it?
But
Do you think that would help?
you're saying, I mean, right now under the law, if my patent issues on year 3, I can still sue people for what happened in year 1, right? Are you saying move it?
Or do the opposite? So
Do the opposite, so that the patent doesn't go into effect for any purpose until it's actually issued. Well, I'm sure that's an interesting idea. I'm sure it would meet a lot of resistance, yeah. But, you have to solve the problem one way or the other. One of the difficulties is that the whole process of understanding claims and working them through has become just very complicated. So the patent office is in a bind.
Just to promote Duke a little bit, we had the PTO Solicitor General chapter. The PTO has issued these continuation regulations that it hopes will reduce continuation prices to some extent. Whether they have the authority to do so is an open question.
Well, and one of the things they're doing is charging higher fees for it, which is, that could be a very workable idea.
But they're also hoping to just give you 2 bites at the apple. Should be interesting. Yeah. Yellow shirt.
Yeah. Well, since you've mentioned that you only see an increased rate of litigation in certain areas, would it possibly indicate to you that it may be a subject matter problem where you're trying to fit, hybrid forms of property into the patent, and you really need, a different paradigm?
I think you may have misunderstood me. There are certain, in some of the new technology areas, the rates of litigation are higher, but the increase has been really across the board. So that speaks to some extent about, some of the new technology areas being a problem, but there's sort of a broader problem that seems to be across the board.
Have you guys thought at all about how to clarify the property rights? I mean, I think that this is the same issue in developing countries, is that nobody's really sure who owns what, and so it's hard for the economy to take off. And here it's kind of the same thing where, you create this norm simply because people expect that, they should respect other people's intellectual property rights because there might be something out there that is a problem for them. Is there are there ways of framing claims or describing the use or potential uses of the patent that you guys have thought of for improving, being able to search for the patents and also being able to reduce their scope?
The institutional changes I suggested is about as far as what we've figured out so far. I mean, I think there are probably a whole lot of other ideas out there that people who are smarter than we are can come up with but what we tried to frame the problem, and we can point to at least some institutional changes that seem to be fairly significant that might help get things in order and make clearance efficient, an efficient process, the clearance of rights efficient. I'm sure there are others.
Could you discuss a little more about using the renewal data? Do you guys take a subset of companies that you knew were actively renewing or actively monitoring patents?
No, we looked at all patents.
Okay.
And one of the interesting analysis is then to break it out by different groups. But
I think we have time for one last question. Is there anyone new, that Joanna?
I was interested in your suggestion that we increase significantly the rates that it costs to renew a patent. And you said that it was likely to reduce people who are opportunistically renewing. I wonder if that didn't seem to be intuitively necessarily true to me. If you could talk about that. It seemed to me that maybe someone who opportunistically was planning on suing would be more likely to actually pay the renewal fee than someone who just sort of wanted to, protect their territory, maybe was a little more defensive about it, and didn't necessarily want it to go out into the public domain.
Yeah, maybe I misstated that a bit. I think the theory, the way it's presented, is this weeds out low-value patents. It effectively gives them shorter terms. I think the connection follows this line of argument, which is that you're talking about patents that aren't generating any revenue stream or any profit stream in the interim. The only hope is that they may do something later, and that's a long shot. So by increasing the cost of keeping that patent, you actually look at the Freeney patent was something that lay dormant for 15 years or something before it was active. The JPEG patents, they lay dormant for nearly till they were expired, until some company comes along and realizes, yeah, we can catch somebody on this one. So if you had that sort of steeper renewal fee structure that's been recommended, I think it would tend to weed out those claims. It's tended to work that way in mining claims, so that you get what you have when there's a mineral deposit's discovered in the 19th century, early 20th century, is you get people rushing in, lots of claims established, and then some of them don't get worked. By having requirements that they be worked and that fees be paid, you basically weed out a lot of the non-productive claims that might later pose a threat to somebody who's working a vein that goes.
I wonder if you would then end up with, say, companies that just buy up all these patents that would otherwise go, sort of as a form of sort of investment in the lottery.
That now, yeah.
And then, it's a business model that people do in a lot of other contexts. It seems like that would just encourage people to hold on to it just so they could do it. It would encourage people that would be their whole job, would be to consolidate these things and invest in the fees and then see what happened.
Right, and so if you make renewal fees much steeper, you're going to tax those companies a little bit more, and maybe it helps.
All right, well, I think you've given us all a lot of food for thought, and I have almost changed it again.
Thank you.